As always, but particularly amazing panel that we have this evening joining us, and I will introduce them in just a moment. I'm Morgan Carroll. I'm a state senator, one of two, for Aurora, and I'm joined by my colleagues also representing Aurora, Representative Rhonda Fields and Representative Sue Ryden, and who may be seeing yet, still Representative Melton joining us tonight. This is a topic that is near and dear to my heart. And my life. And the topic, it's sort of a misnomer to call it a topic because it's pretty much everything you can think of that could possibly come up is touched and impacted in some way. And it's very personal issues as far as family. It can be the legal system, the court system, the criminal justice system, and we're here to talk about a panel on disability rights. For a little bit of context, and it's always hard to know exactly, but according to the census, about 1 in 5 people have a disability in this country, and it's maybe more than people realize because a lot of disabilities you can't see. And that is important for us to realize when we really want to get our minds around how many different ways we can see issues expressed. Out of that, at least according to the census, about 17% of folks actually have a functional limitation associated with a disability. And out of the 1 in 5, or about the 19% of folks with a disability in this country, about half meet a definition of what's considered to be a severe disability, or about 24 million people in this country. For me, my dad, he was diagnosed with Parkinson's, very early aggressive onset Parkinson's when I was 2. And my dad went through multiple brain surgeries with that. And so I saw firsthand what a neurological disability and a progressive advancing disability looked like growing up. So we are looking at how we can better improve disability rights, and specifically we're talking about people with all the different ways that this can be expressed with different disabilities. Where are the policies at the local level, the state level, and the federal level? And they really do impact at every single level if we want to make sure that we are a fully inclusive and equal rights-based society. So just to kick us off with a few thoughts, this obviously we start with issues like housing, and we have different accommodation challenges on housing. We have affordability challenges on housing. Transportation is an angle that poses additional challenges. Work. And work and discrimination in the workplace, accommodation in the workplace, but finding access for those who can work to make sure that we are hiring the people who can. SSI and SSDI on Social Security, disability benefits, healthcare issues, whether it's private sector healthcare, whether it's Medicaid, whether it's Medicare, discrimination aspects. And I want to end with what I consider a civil and a human rights aspect, because how we do or don't address every component of society is a measure of who we are, and are we doing what we need to be doing in education arena? Are we doing what we need to be doing in the legal arena? And so that is obviously an enormous range of potential topics, and we've got a great lineup for tonight. So what we'll do is, as we usually do, we will be hearing about 3 to 5 minutes or however long from each of our panelists here. And then after that, we've got a microphone here where come up and join us, ask any questions. If there's anything you want to know that wasn't addressed here, please feel free to do so. And I am going to go ahead and kick off. I'm not sure if you guys got this, but this is a sheet that includes a bit of an intro about who each of our panelists are. And we've got Josh, who is starting us over on this end here. And if you guys wouldn't mind, just introduce yourself if you're with an organization. And 3 to 5 minutes of what you think is maybe most important, most timely, what people may not know, how people can help.
Thanks a lot, Senator Carroll. So my name is Josh Winkler, and I am the Vice President of the Board of Colorado Cross Disability Coalition. The Cross Disability Coalition is a statewide organization that kind of has 3 arms to it. We do a lot of public policy work, working on new legislation, on pieces of legislation. Then we do a lot of individual advocacy work, and then we actually have a legal arm that goes and fights down the court system when some of the other angles don't work, or on individual cases that have gone really bad. One of the things that we've kind of moved to in the last year or so is a major focus for the Colorado Crisis Disability Coalition is disability employment. For years, it's been near impossible for people with disabilities to work, receive the benefits they need to survive, and keep a roof over their head. You have to be careful not to lose your Social Security qualification, because Social Security's definition of disability is based on ability to work. So the fundamental definition of disability says you can't work, and then they'll tell you, oh, but we have employment incentive programs for you. Well, if you work too much, then you're no longer disabled. So it's kind of a catch-22. In the last few years, things have improved a lot, nationwide, but especially here in Colorado. 3 years ago, I think now, the Medicaid buy-in programs for both adults and children rolled out. So if you have a disability, if your child has a disability, you can buy in and get them Medicaid. If you're an adult with a disability, you can work and buy into your Medicaid. And it's one of the best programs in the country as far as how it's set up. You can actually earn up to $100,000 a year roughly and buy into Medicaid. You pay a couple $100 a month for your Medicaid services, but that's well worth it for those of us who really need Medicaid. Myself, I get twice a day home health care. That's $40,000 a year roughly. Like, I can't, even earn $100,000 a year, you can't afford to spend that and still live. So it's a great program. It's been a little bumpy start, but it is getting better, and we keep working on all the other areas, making sure that people get the accommodations at work, making sure that people know, when you hit a limit, there's going to be a limit on Social Security. That's one number. There's a different number for Medicaid. There's a different number for your housing. And Senator Carroll mentioned affordable housing. There was a time that you could have a Section 8 voucher, lose that Section 8 voucher because you got a job, and know that you could go back and reapply and get another one if your employment didn't work out. Those days are over. A Section 8 voucher, unfortunately, is coveted now. And I don't know anybody who's willing to just give that up to chance that their job's going to work out. So we still have a lot of bumps in the road. One of the major problems for working is, under the Medicaid system, the newly eligibles, what they call the MAGIs, the modified adjusted gross income eligible folks, they don't have an asset limit. So they get basic Medicaid, which is your doctor and your hospitals, that kind of stuff. Those of us who receive long-term care services, we're held to a $2,000 asset limit unless we qualify for the buy-in. If you qualify for the buy-in, I'm on the buy-in. I send a check for $130 a month for my Medicaid. When I turn 65, that program I'm no longer eligible for, and the asset limit reapplies. So I'm encouraged to save money, build a retirement, and the day that I'm able to retire, I'm no longer eligible for Medicaid. I'm lucky. I'm 35. We have 30 years to fix this problem. I expect we will in the next 30 years. But there's a lot of folks who are in their 50s and 60s who don't know that that's going to happen. And that's probably federal level. I mean, there's so many things we can fix at the state level. That particular one is actually a federal level issue. We can do some things around asset limits at the state level, but a lot of that actually is at the federal level, which is why we're rooting for Senator Carroll over here to get into the federal level and help us fix some of the things up there. So, I mean, there are advances coming in Colorado. I mean, we really have moved a long ways. Our Medicaid program for long-term care is one of the best in the nation. Housing, I don't know anybody has a solution for that. And the employment picture is slowly getting better, but it's still really tough to navigate, and folks are still kind of getting caught in the cracks and being told one thing by their county, another thing by the state, another thing by an advocate, because it's new programs, and those are always hard to navigate. So that's a little bit on the disability employment picture.
Actually, I have a PowerPoint, which is going to be quick. But I'm Carroll Stewart. I'm with the Arc of Aurora. And I wanted to talk a little bit about a new law that Colorado adopted July 1st, 2016. It's regarding mandatory reporting of at-risk crimes against at-risk adults with intellectual and developmental disabilities. How many of you know somebody with an intellectual or developmental disability? Or perfect. So this is an important discussion to have. So as of July 1st, certain professionals, is that up?
Trying to get the screen.
Sorry. Put a little more.
Probably shouldn't.
Is that, can folks see that?
Yeah, I can see fine.
Okay, great. As of July 1st, 2016, certain professionals are mandated by law to report crimes against at-risk adults with intellectual and developmental disabilities. A similar law was passed earlier in 2014, and that law had to do with elders, at-risk adults who are elders over the age of 70. And that happened in July 1st, 2014. So here is a list of some of the mandatory reporters. People who historically had been urged to report if they suspected a crime had been committed, or actually saw a crime be committed, and those crimes deal with mistreatment, which is abuse, neglect, and exploitation. But there are some people on this list who have never reported a crime because they haven't necessarily felt like they had the information or had the obligation to do it. So here is a list of some of the mandatory reporters. So in Colorado, the definition of a developmental disability is it's attributable to a mental or physical impairment, happens before the age of 22, likely to continue indefinitely, and reflects a combination of specialized supports which are lifelong. That includes people with autism, cerebral palsy, Down syndrome, Fragile X, and the list can go on and on and on. But what's important to know is if someone receives special education, they may be an individual who's eligible to be protected by this law. Or if they are receiving services from a community center board, they are absolutely defined as somebody who has a developmental disability. So when this new law passed in 2014, there were several definitions. Adult Protective Services had their own definitions, and law enforcement had their own definitions. But actually, I don't know why this is progressing by itself. This happens to me frequently when I do this presentation. But mistreatment had all sorts of definitions, and so when we passed, again, this law in 2016, can you help me make this stop? Sorry.
Quite like auto.
Yeah, I don't know why it's doing that. We decided to create one definition for mistreatment. One definition for law enforcement, one definition for adult protective services. This was critical because prior to that, adult protective services was identifying one thing and law enforcement was identifying something else. So those definitions, and I did put the PowerPoint in the back, has a new definition of abuse, mistreatment, and the new part of the mistreatment part is where a caretaker knowingly uses harassment or undue influence or intimidation to create a hostile or fearful environment. For many people with intellectual and developmental disabilities, they spend their whole life dependent upon support by others. And many of those individuals will tell you when no one else is around, what their staff members tell them they're going to do, or what their staff members do. So putting this in here really was an opportunity to help begin to have that dialogue. And then exploitation is primarily around forcing someone to either give money or to perform work that is otherwise not paid for. So what do you need to know if you're a mandatory reporter? Because this is really the crux of the law. If you witness or become aware that an at-risk elder or an at-risk person with intellectual or developmental disabilities has been harmed through abuse, neglect, caretaker neglect, or exploitation, or you believe they will be harmed, you must contact law enforcement within 24 hours. Within 24 hours. If you witness abuse and become aware of abuse, you must report. And reporting to your supervisor, which has really been the crux of both the at-risk elder law and this law, isn't sufficient anymore. Your supervisor does not have the direct knowledge. If you work for an agency and they give you a protocol that says, well, contact your supervisor first, the law says contact law enforcement. Your supervisor is not responsible. Failure to report is a Class 3 misdemeanor. And I do know when this law passed for the elder community, there was somebody who actually brought a nursing home staff member up on this charge because they had been there numerous times, re-educating, and at some point there had to be some accountability. Somebody wasn't getting it. and that was in Jefferson County. Mandatory reporters are not investigators. So you don't have to investigate the crime. You don't have to say, well, I absolutely needed to know. I saw somebody slap that person, but I wasn't sure if I should do something. Don't worry, that's law enforcement's job. Self-neglect is not a crime. And you shouldn't call law enforcement on somebody who's a hoarder, because that's not a crime. These are things: abuse, caretaker neglect, or exploitation. And if you are the perpetrator, calling doesn't make you immune from charge. So when you call law enforcement, what do you need to know? Aurora Police Department has been very active in this particular discussion. They want you to call. They want the name and address of the at-risk elder or the person with IDD, the alleged description of the mistreatment or the situation. Did you observe it? Are you aware of it? How did you become aware of it? Is there an injury? Who is the perpetrator or the alleged perpetrator? The name and address and any other relevant information. One of the things that we've been telling folks too is to, at that point when you make that call, is to say, do you want law enforcement to come and visit you? Because sometimes dispatch takes the call, and that's the end of the discussion. So if you want law enforcement to come and talk to you about this report, you need to say to the dispatch officer, I want a follow-up by a patrol officer. So what happens after the report is made? Law enforcement has to share with Adult Protective Services and the District Attorney's Office within 24 hours that they have been contacted about a particular alleged allegation of abuse, caretaker neglect, or exploitation. Law enforcement may investigate. They may not. Adult Protective Services may investigate, and they may not. And that's very important to understand. One of the calls that I just went through with somebody, they said, well, this person, they had caretaker neglect. I said, so what happened? And they said, well, the caretaker left him alone for 2 hours. And his plan says he could only be left home for an hour. So we called the police, but the police said there's no crime. So what does this mean? I said, well, was the person harmed when they were left alone? Was there something that resulted in something that was irrevocable, that they couldn't be? No, they just left him alone, and the plan said they only get an hour. I said, as much as that's frustrating, because that's what the plan says, that's an Adult Protective Service phone call. That's not a law enforcement, because there's no crime. Caretaker neglect has its own definition. So they may or may not investigate. Law enforcement, when they're done, will work with the DA's office, and all along the DA will follow the case, but they may or may not, even if law enforcement investigates, even if they believe there's probable cause, even if they strongly support that something be done, the District Attorney's Office may not prosecute. So what's the roles of law enforcement and APS? And that's really, really important. APS is the civil side of investigations. Law enforcement is the criminal side. And so they will collaborate together. They do collaborate together. Sometimes law enforcement gets a phone call. They can't really do an investigation because there isn't anything criminal. They can call APS and say, Adult Protective Services, and say, hey, you know what? We've been out to that home 4 times. Something is definitely wrong, but we can't see anything that's criminal. So ultimately, they're allowed to partner. So there's some upcoming trainings there in the back that I put back there that's being conducted on what every mandatory reporter needs to know. And it's through a collaborative involving our district attorney out of Arapahoe County, Aurora Police Department, all the community center boards, the mental health agencies in the Arc of Aurora, to talk in detail what you need to know if you're a mandatory reporter, what you need to do to protect yourself, because that's really important for you to recognize that this law does again create an opportunity for you to be held accountable for not calling. But ultimately, the most important part about the mandatory reporting law that folks need to understand is it isn't just more hoops or more government. Statistics say that 8 out of 10 women with intellectual and developmental disabilities will be sexually assaulted. 8 out of 10. That's a lot of people. How many cases do you think are prosecuted? Less than 1%. It's important to understand that this law is intended to create a stronger protection, to catch the bad people, to involve law enforcement when it's time for them to be involved, and to assist them in recognizing that people with developmental disabilities don't need any more social workers. If you know people, and I saw everybody raise their hands, then you know there's a lot of social workers and a lot of community workers and there's a lot of helpers. They need justice when they're victims of crime. And that's what this law was all about. So thank you.
Actually, I'm doing one too, if that's all right. And I'm just gonna do I had 15 minutes worth, but I won't do 15 minutes. Sorry. I'm gonna do a 2-minute video and then just tell you 2 of the main things that I wanna talk about. So my name is Allison Daniels. I'm the Director of Legal Services at Disability Law Colorado. We are Colorado's protection and advocacy agency. And that's what our video is about. So our mission is to protect and promote the rights of people with disabilities and older people through direct legal representation, advocacy, so non-lawyer advocacy, education, like trainings, and legislative analysis. So here is a short video.
All people deserve basic human rights. That's why Congress created a system of protection and advocacy agencies, also known as P&As, to protect and advocate for the rights of people with disabilities.
Oh, I'm sorry. I wanted it to be on the whole thing.
All people deserve basic human
Sorry.
rights. That's why Congress created a system of protection and advocacy agencies, also known as P&As, to protect and advocate for the rights of people with disabilities. Because in the past, they have not been treated equally. In most of the 20th century, the phrase out of sight, out of mind was more than just a popular saying. It was the means for dealing with an unwanted segment of the population. People with disabilities were either segregated from society, locked away in institutions, or remained isolated at home with absolutely no services, not even an education. They were abused, neglected, and forgotten. Then, in 1973, ABC news cameras exposed the filthy living conditions and poor treatment inside Staten Island's Willowbrook School, which housed people with developmental and intellectual disabilities. It shocked the nation.
The doctor was telling me that it would be bad, horrible.
Finally, in 1975, Congress acted. They mandated that every U.S. state and territory have an official protection and advocacy agency. P&As go by many names, but their mission is the same: to protect and advocate for the rights of people with disabilities. Together, the P&As form the National Disability Rights Network, taking on issues affecting people with all kinds of disabilities. No other organizations have the sweeping access authority that P&As have, where services for people with disabilities are provided, from schools to hospitals to prisons and jails, to monitor conditions and listen to concerns. They make sure people with disabilities are treated equally, with dignity and respect, and never have to face the same kind of mistreatment they saw at Willowbrook. P&As ask the public for input on which issues to take on in their communities. P&As can fight against abuse and neglect in residential services, to end exploitation at work, for fair treatment in the criminal justice system, for equal access to public education and voting, for accessible communities and services, and assistive technologies, and countless other issues. That's the protection and advocacy system. Click here to find the P&A for your state or territory, and subscribe for more videos from the P&A.
Okay, so that is what the protection advocacy does, and we are Colorado's protection advocacy. And the types of things that we have decided that we are going to do as an agency are housing, animals, voting rights, investigations of abuse and neglect, denials of Medicaid services for folks with intellectual and developmental disabilities. But the 2 main things that I want to focus on today, since we have limited time, and I do have the PowerPoint in the back, and I have some materials in the back if you want information. We have a great website, and you can call us and get more information. But the 2 things I want to focus on are education. One of our big pushes this year is about restraint and seclusion in schools. So what this is talking about is kids with disabilities who are in schools and are being physically restrained or being locked in rooms alone, isolated, and the terrible effects that it has. Our current law does not provide any enforcement if schools are found to have violated the rules regarding that. And our current law does allow for people to be restrained, not people, children, to be restrained face down in a very dangerous situation. Mental health facilities, state hospitals, the Division of Youth Corrections, they're not allowed to use that, but the local public school is allowed to use a prone restraint. We think that's a big problem, and we're going to be looking to our legislators to help us with that next year. We work on housing, we work in employment. The other big thing, though, I want to mention is animals. Animals is a huge issue right now because there was a law passed earlier this year that goes into effect January 1st, and it's about service and companion animals. Service animals are only, under the Americans with Disabilities Act, they are only dogs or miniature horses. Companion animals can be any type of animal. So a service animal is allowed to be with a person in King Soopers, in a hospital, in a restaurant. Wherever the person goes, a service animal is allowed to go. A companion animal is a completely different situation, and they are only allowed generally in housing. And that's because the reasoning is we want people to be comfortable and feel safe in their homes, and if they feel comfortable and safe with an animal, then we want them to have an animal. Even if normally pets are not allowed, companion animals are not considered pets. So companion animals are allowed in the home, and it can be a cat, it can be a bird, it can be a lizard, but that cat, bird, lizard,